hear argument? State?
Your Honor, we reserve our time for rebuttal, Judge.
All right, defense, the court will hear argument, and you all can remain seated.
1 second. If it please the court, Judge, we're at the end of the trial, and we heard from several witnesses, and I feel, based on the evidence, one of the important witnesses was the fingerprint exam. When I asked her the question, ma'am, can you determine how long or how long a fingerprint has been on an object, or could you determine the age of a print? And she said no. I asked her, could you tell whether it's been 2 months, a year, 2 years, 5 years? You remember the statement? And she couldn't tell. She could not make that determination. She could determine whether, based on her expertise, whether or not the print was made by a person. She can't tell when it was made, or where it came from. And the mere fact that a print was found on an object inside the residence without any timeline as to when or how or whether before that even as they was placed there, they don't know. There's no explanation for it. Our position is that the state has failed to meet their burden to charge them with burglary.
Your Honor, please the court. Well, we heard from several officers in this case. So just to refresh the court's memory, we heard from Officer Lesperais, who was the first on the scene. He went to the apartment, did a protective sweep. He saw the pry bars and the wrenches in the bedroom safe. He saw that the bedroom safe had 3 bullet defects in it. On his body cam, we could see that in order to get to the safe, you had to go through the living room, through the bedroom, through the bathroom, into the very back of the apartment, to the closet. Next, we heard from Officer Trevino. He went to Kelbron's apartment. He saw that the door was damaged, as if somebody had broken in. He saw that the apartment was ransacked. We heard from Detective Morales, who testified, and we saw from his body-worn camera, that the defendant told Detective Morales that he didn't know Kelbron. He'd never been to his apartment. So with these facts, it's undisputed that the defendant had no legal reason to be in Kelbron's apartment. The safe is in the very back area of the apartment, and the safe keypad where the defendant's fingerprint was found was something that the burglar necessarily had to touch. The safe was clearly tampered with, as if someone was trying to break in. And then I just want to, some of the case law on this, the CCA has held that circumstantial evidence is frequently just as convincing from the facts that were presented here. The fingerprint being on the safe that was, on the safe keypad that was removed from the safe, that necessarily had to be done by someone who was trying to break into the safe, Judge. And I think a reasonable inference from what we brought you to in this case, including the statement from the defendant where he says he didn't know the complaining witness, he'd never been to his apartment. I think it's a reasonable inference that you can make when he had no legal reason to be inside the apartment, that there was a burglary, Judge. The only other CCA case I want to mention is that you can make, Judge, when you combine how the apartment was ransacked, the door was busted open, and the attempts to enter the safe. Combine that with the fingerprint and the defendant's statement that he didn't know the defendant. Didn't know the complaining witness that had never been to his apartment, Judge. I think that's a reasonable inference from the evidence in this case. We believe, or Judge, we're asking that you find the defendant guilty of burglary.
Okay. So I had a chance to listen to all of the evidence and listen to it with my mind towards what's in the indictment. So with the burglary of the habitation, first element is the date. I think you satisfied the date. I think you satisfied Bear County. So the only other issues are, did someone unlawfully enter, from your witness's testimony, many fingerprints inside that apartment? That's what I recall from what the witnesses testified to. The problem is, with the fingerprint on a safe, with a fingerprint on a knife, with a fingerprint on a refrigerator, those are movable objects. And when I say movable objects, I know that the safe was nailed down or secured. Nobody knows when that safe was nailed down or secured. I know that the witness is stating that this defendant's fingerprint was on the keypad. Nobody knows we're there. Where is that evidence other than this fingerprint that's on the safe that nobody can tell the court when that fingerprint was placed on the safe? Do we have a fingerprint on a doorknob? Do we have a fingerprint on any of the tools that people are saying that was alleged to have been used to illegally enter this residence? Those are all things that I look at. And I understand that inferences can be made. I understand circumstantial evidence. But in this case, that's all I have. I have on 24A that you have an officer saying, this is capital murder case. Well, we're not here for capital murder. We're here for a burglary of a habitation. So that's what I have. And as both parties know, state and defense, when you come before me on a bench trial, state, if I think you've proven your case, I will find somebody guilty. Defense, if I think they have not proven their case beyond a reasonable doubt, then that person's going to be found not guilty. It doesn't matter in the sense that, oh, this is a murder case. Oh, this is a capital murder case. I'm just going to go by what facts were presented to me as beyond a reasonable doubt. So I'm going to find the defendant not guilty. Is there anything else from either side? All right, we can go off the record. Mr. Romero, I wasn't at the scene on this day. I don't know what happened other than the evidence that's presented to me. You know who you are, and you know whether you did something or didn't do something. I always tell people, and I would tell my clients, when we go to a jury trial, if you're found not guilty, that's not saying you're innocent. It's only saying that the state didn't prove their case. And there are many times where the state may have a case and somebody's found not guilty. It doesn't mean were they able to prove their case beyond a reasonable doubt? You know who you are, and you know if you've done something or have not done something. But what I'm going to tell you is, for the rest of your life, you have better decide what you're going to do and not come back to a felony court for allegedly doing something improper. Do you understand? Is there anything else from either side?
No.